All right, welcome everybody to another question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin, and I'm here on this beautiful Friday afternoon to answer all of your questions related to employment law, workplace issues, anything at all related to work and employment. I am here to answer your questions for the next half hour or so. Send in your questions, anything you might be wondering about, whether it be related to COVID. We've been getting a lot of questions lately about vaccinations, rightfully so. That's become a very kind of hot topic. So if you have any questions about vaccines, please send that in. Any questions about termination, severance pay, workplace issues, workplace safety, especially now as we enter into step 3 of our reopening in Ontario. There's a lot of questions that have arisen with respect to restaurants, restaurant workers being able to work inside now, and lots of changes happening throughout the province. So if you have any questions related to anything at all in terms of employment law, workplace issues, now is the time. Send them in, and I'm happy to answer your questions. I have a few things that I thought would be of interest to talk about today. I'll start to go through them as we wait for some questions to come in. Hopefully I'll have lots of questions, and I like always will not be able to get through my list. I'd much rather answer your questions and talk about the items I have on my list, but in any case, I'll start going through some of the things that have been coming up recently that I think a lot of people would be interested in, and these are issues and questions that come up very often. So we'll start talking about those, and then as the questions come in, we will deal with them one at a time. So the first thing that I wanted to actually address, which surprisingly has nothing to do with COVID, which is usually what we talk about during the beginning of these types of sessions, is with respect to probation. So I've had this question come up a few times in the last few weeks, and I think as the pandemic starts to improve and people start to go back to work, or businesses start to hire new employees, especially in some of the industries that are now going to hopefully come back to life after being shut down for so long, like the restaurant industry, we're getting a lot of questions about probation and probation clauses. So it's really important to know that in Ontario, there is a section under the Employment Standards Act that basically sets out that if an employee is let go within the first 3 months of their service, of their work, that there doesn't have to be any notice or pay in lieu of notice provided. In other words, severance pay. Now, that is correct. However, in order for that to apply, it actually has to be in a written employment contract. So if you're an employee and you don't have that in your written employment contract, or you don't have an employment contract at all, then it doesn't apply to you. And even though you're let go within your first 3 months of work, you still would be entitled to pay in lieu of notice or notice of your termination. And that amount will vary depending on your age, your position, your compensation. But there will be an amount that's owed. It won't be nothing just because the Employment Standards Act says that. It has to actually be incorporated into a written contract in order to apply to you. So that's really important to keep in mind, because a lot of employers, will simply let somebody go and mention that you're in your probation period, you're in your first 3 months, so they don't owe you anything. So it's important as an employee, the takeaway is that's not necessarily the case. It's only the case if you've signed a contract that says that, and the language is enforceable and valid, which most of the time it's not. So if you're an employee and that happens to you, it's really important to get advice from an employment lawyer. And you can always contact us by going to our website, employmentlawyer.ca, or you can email us at help@employmentlawyer.ca. And similarly, if you're an employer, it's important to keep this in mind as well, because oftentimes we get questions from employers who think that they don't have any liability because you're in the 3-month probation period. Again, that's only the case where you don't owe notice or severance pay if the employee has signed something where they agree that that applies. If there is no contract in place, or if the contract that's in place doesn't mention or properly mention probation and how a termination during probation would occur, then there is liability there on the employer's end as well. And again, the severance or the notice that you need to provide will vary depending on the employee's circumstances, but there could be liability there. So whether you're an employee or an employer, it's always good to check with a lawyer before you make any decisions with respect to these things, because it might not be as simple or as obvious as it might seem. Now, with respect to probation periods as well, the other item that I wanted to discuss, aside from termination during probation period, is the length of the probation period. So if there is a termination clause in a contract that an employee has signed that says you're subject to 3 months probation, and if you're let go during those first 3 months under the ESA, the Employment Standards Act, you won't get any notice or pay in lieu of notice. That's fine, but it only applies for the 3 months. So if you are an employee who has signed a probation clause that says that that will be for 6 months, that's unlawful. That's in breach of the Employment Standards Act. It can only apply for the first 3 months. And then beyond the first 3 months, even if your employment contract says that you will only receive what's in the Employment Standards Act, which is quite rare, but even in a situation like that, you would then still be owed notice or pay in lieu of notice after those 3 months have expired. So it's really important to keep in mind that even if a contract says it's 6 months or 9 months probation or whatever the case may be, or if you're an employer, your employer is telling you that you're still in your probation period so they don't have to give you anything, it's not necessarily the case. It's only in a very limited set of circumstances. So again, for employees and employers alike, very important to keep that in mind so that as an employee, you make sure that you're receiving what you should under the law. And as an employer, you are acting in accordance with that law. So I have a question coming in here that I'm going to get to now. So I have a question from Al Vashaw on Facebook, who asks, does a private company have the right to mandate injections, i.e. COVID-19 vaccines? Sorry. And then he says, as COVID-19 injections don't fit the legal definition of a vaccine. So I can't comment on what the legal definition of a vaccine is because that's a medical or scientific question. But I can comment on, private companies and the mandating of vaccinations, specifically COVID-19 vaccines, because that's what we're dealing with right now. So unfortunately, it's a bit of a gray area right now. What I can tell you is vaccines in most workplaces cannot be mandated. So an employer, in other words, cannot force employees to get vaccinated. In certain circumstances, there are exceptions, particularly in unionized environments. There have been decisions that have come out with respect to nurses, for example, who for the most part are unionized. And there have been decisions made where that has been challenged. The hospital, for example, implementing a mandatory vaccine policy for nurses, that has been challenged. And the decision maker in those cases has determined that they can make vaccines mandatory, but those are in very, very limited situations. And obviously it's for healthcare reasons. Most workplaces are not in a situation that's similar to that. In other words, if you work in an office, if you work in any kind of industry that's not healthcare related, and even in some healthcare related industries, the employer can't, in general, force employees to get vaccinated. So that's something that we've been seeing has been coming up a lot lately. They cannot force you. You have to keep that in mind as an employee. The employer can never force you to be vaccinated. In terms of implementing a workplace policy that says that you need to be vaccinated in order to, let's say, return to work or keep doing your job, that's where it's a bit of a gray area in terms of what the legal consequences will be. So what I mean by that is they can't force you to get vaccinated, but then the question, to your point, Al, becomes, well, what's the end result? Because if they can't force me to get vaccinated and I don't get vaccinated, but I can't return to work, where does that leave us, right? And that's the question that we're getting from a lot of people right now. And so in terms of, what an employer can do, it depends on the reason for the refusal. So if you're refusing the vaccine for any of the grounds that are protected by human rights legislation, they cannot let you go because of it. So what that means is if you're refusing the vaccine or you're refusing to get vaccinated because of a religious belief or a medical condition, for example, your doctor says you actually can't get vaccinated. Maybe you want to get vaccinated, but you have a medical condition or an allergy where you simply cannot get the COVID-19 vaccine. In those situations, there is nothing an employer can do in the sense that they cannot let you go, that's for sure, and they cannot treat you differently because of it, because that is a ground that's protected by the Human Rights Code. And so you cannot be discriminated against on those bases, and you cannot be treated differently, in essence, because of those things. Now, when it comes to something that isn't protected, if, let's say, there is no ground that you're basing your refusal on, based on the human rights legislation, then it becomes a situation where it's a reason for termination that is allowed by law. It's just a question of, are they going to provide you with the proper amount of notice and or severance pay? So in other words, an employer cannot discriminate against you if you're refusing based on a code protected ground that's protected by human rights law. And they cannot terminate for cause, because that is not an example of egregious misconduct that would justify a cause termination, meaning a termination where they would let you go without any notice or any severance pay. That's something that's not going to fly, that we know for sure. In terms of other types of grounds that we might see come out in the legislation and other reasons for which you might refuse to get vaccinated, that's where it's a gray area, because this hasn't been addressed by the courts. But one thing that we know for sure is no employer can actually force you to get vaccinated in the vast majority of cases. I hope, Al, that's helpful. If you have a more specific situation that you're currently dealing with, because every single situation is different depending on your industry, depending on your reasons for refusing the vaccine, depending on how your employer responds to that, reach out to us. You can email us at help@employmentlawyer.ca. You can go to our website, which is employmentlawyer.ca. We have all of our lawyers' contact information on our website, so you can contact me or any of the other lawyers so that we can provide you with advice about your specific set of circumstances, because this is, of course, just kind of general advice and general commentary on a very interesting but very broad topic. So every situation is different, and if you are dealing with a situation where you don't want to be vaccinated, your employer is giving you a hard time, or they terminate you because of it, get in touch with us right away so that we can assist you and let you know what your options might be. All right, I have another question coming in here from Facebook. Mark Robillard says, I work with a non-union company and have been laid off since COVID started. They just recalled me back today to start in a week. However, I am in contract with another job until October. Do I have to return in a week, or can I tell them a start date? What are my options? Great question, one that we're getting a lot now with people being recalled back to work. So in terms of your set of circumstances, Mark, if you don't go back to work when you're recalled, because it looks like you've accepted your layoff, you've been on a layoff this whole time, you've accepted it, that means that you're waiting for a recall. You have the ability to seek other work while you're on a layoff, and that will not affect your recall rights or potentially any termination issues that might come up. But when you are recalled back to work, you have to return back to work within a reasonable amount of time. If you don't, it will be considered a resignation. So if you're on contract with another job until October, that wouldn't be considered a reasonable amount of time between, July and October. What could be considered a reasonable delay, if, they give you maybe a week's notice, but you need 2 weeks notice, that could be considered reasonable. A lot of people in your situation, in layoff situations, have childcare obligations, and so they need a couple weeks to get their affairs in order to go back to work. That's perfectly reasonable, and all employers should accommodate that type of request because it is reasonable. Pushing it off to October is not something that they have to do. Now, having said that, just because they don't have to accept that doesn't mean it's not something that you can raise with them and see if they'll agree to that. and let them know that, you do want to return to work, but you sought other work while you were laid off and it ends in October, and see if there's any way that the parties together can agree to this mutual date where you return to work in October. They don't have to, but they might, depending on, your work history with them. If you have a long-standing employment relationship and a very, good work history, they might agree to it, to have you come back then. Otherwise, you have a decision to make with respect to whether you're going to leave the job that you're on contract until October with, which sounds like it's just a contract job, doesn't sound long-term, or go back to what would be considered your long-term employment. Because if you resign from, let's say, a long service position, you'd be giving up potentially in the future, if they decided to terminate you, you'd be giving up those rights to severance pay because you're resigning. And when you resign or you leave your employment, you're not entitled to any severance pay or any notice. That would only be for terminations. The only thing you are entitled to receive at the time of a resignation would be all of your outstanding wages, if there are any outstanding wages, and then your vacation pay that has accrued up to your date of resignation. But short of those two things, there wouldn't be anything else owed to you. So in a situation like that, if you're, in a situation that like Mark is in, where you found other work, it hasn't come to an end, and now you have a decision to make, you'll have to just weigh the pros and cons and figure out what works best for you. My suggestion would be not to give up very long service permanent employment to the benefit of something that might just be a contract where there's no opportunity to continue working there, because come October, you might find yourself out of work again, of course, depending on the industry that you're in. So, it will depend on your exact circumstances, but from a legal perspective, they don't have to hold off until October. So if you want them to hold off, a week or two, that's reasonable. Anything beyond that would be considered a resignation if you don't return to work. So have that conversation. I definitely recommend that you have that conversation. This is an issue that's been coming up a lot lately, and my advice to people is always to have a conversation with your employer first. This is a time during the pandemic where people are in high stress situations. We're all in situations we haven't dealt with before. Most employers and most employees all mean well. It's just a matter of communicating. So it is possible that if you communicate with them, they will accommodate your request. But if not, then you have a decision to make, and every situation is different. So I always say, start with a conversation, see if that leads to the result that you're hoping for. And if not, then you do have a tough decision to make, unfortunately. All right, just scrolling through. You're welcome, Mark. All right, so looks like not as many questions coming in right now. Once again, I'm here for another 10 minutes or so. So if you're watching and there's anything that you've been wondering about, thinking about, now is the time to ask. Send in your question. Anything to do with employment or the workplace, or returning from layoffs, terminations, whatever the case might be. Now is the time to send in your questions, and I'm happy to answer any and all of the questions you might have. Otherwise, if you are watching and you might not want to publicly ask your question or provide your question right now, you can always contact us away from this question and answer session. And again, the website is employmentlawyer.ca. You can contact us by, contacting any of the lawyers on our website, including myself. All of my contact information and all of my colleagues' contact information is there. And otherwise, you can also email us at help@employmentlawyer.ca. So whatever works best for you, whatever is more convenient. If you're not sure about asking a question right now, or maybe you don't have a question to ask right now and one comes up throughout the week, we do a few of these question and answer sessions throughout the week. But if not, you can always email us, like I said, help@employmentlawyer.ca. The email address is on the screen, and we can help you that way as well. So I'm going to continue going through my list of things that came up in the last couple of weeks while we see if we have any more questions coming in today. And what I wanted to talk about is actually related to COVID. So In terms of COVID-19 issues, the most prominent issues that we're seeing is one that I've touched on a couple times over the last few months. So I won't spend much time on it, but I just want to mention it because not a week goes by that I don't see something like this happening. And so when we're looking at situations where people are being recalled from a layoff, just like the situation Mark was asking about, it's important to understand that you have to be recalled back to the same exact position. Same position, same pay, same hours of work, everything the same as if you had not been laid off, as long as your job still exists. So the caveat is if your job doesn't exist, if, let's say, throughout the pandemic, your employer has gone through a restructuring, they've eliminated departments or divisions, or streamlined some of their operations, it may be that your job doesn't exist anymore. If that's the case and your job doesn't exist, then they have to put you to the next best comparable job, if that exists. If there isn't a comparable job, in other words, a job that's similar pay, similar hours, similar position, it's not a demotion, maybe it's a lateral move, maybe the pay is similar, maybe it's a little bit less, but it can't be more of a reduction than 10% on an annual basis, because that would not be considered comparable. Any of those situations, that would be okay. But you don't have to accept a job that's not comparable. In other words, more than a 10% reduction in your annual pay, very different hours, a demotion, a change in location where you now have to commute an extra hour each way. Whatever the case may be, these are all examples that we've seen over the last few months, and quite frankly, over the last couple of years. But those are not situations that have to be accepted. You can refuse those things, but make sure you do so upon receiving legal advice. So if you're not called back to the exact same terms and conditions of employment, you should definitely be seeking legal advice, because it's a very subtle analysis in the sense that every situation is different. And so it requires a lawyer's expertise to look through your specific circumstances and figure out, is this job that you're being offered to come back to comparable to your previous position or not? And that's where it takes an employment lawyer to tell you if it's comparable or not and what your options are. If it's not comparable, you don't have to accept it, and it could amount to what we call a constructive dismissal, where you're owed your termination entitlements, but you have to get the advice from a lawyer first. Extremely important that if you find yourself in a situation like this, you don't resign, you don't tell them I'm refusing the position, give me my severance pay. You speak to a lawyer first and you get advice so that you can approach it in a strategic manner, and we can guide you behind the scenes. And this is what happens in a lot of situations where people contact us when they're going through this situation, the changes are starting to be made or they're starting to be proposed, either while they're working throughout their tenure, or when they're being called back to work, these changes are being imposed on them, and we guide employees behind the scenes so that they can best protect their rights. You don't want to end up in a situation where you simply resign or refuse to go back to work, do nothing about it, and then let's say contact us 2 months later. At that point, it's going to be too late. So these are important situations where it's imperative that you get legal advice from an employment lawyer so that you can make sure you take the right steps to protect yourself. So when it comes to these COVID layoffs, that's really important to keep in mind that if you're called back to work, it has to be the same job, the same terms and conditions of employment. And if it's not, as I said before, that's when you reach out. You can reach out to me, you can reach out to any of our colleagues by going to employmentlawyer.ca and getting the proper legal advice that you need to make an informed decision about what to do, because you don't have to accept that type of situation. The other thing that's important to keep in mind in terms of being called back to work after a COVID layoff, or any layoff, but specifically COVID is trending right now, is that you don't have to sign anything. So we've been seeing a lot of employers who are having people come back to work, and it's not the issue I just mentioned, back to the same job, same position, duties, pay, hours, everything the same. But in order to come back to work, they want you to sign something. And it can be a 12-page document, it can be a 2-page document, it can be a 1-pager, whatever the case may be, you don't have to sign anything as an employee to go back to work after your layoff. I've seen lots of different terms that employers have tried to put into documents to get employees to sign and try and make returning to work contingent on an employee signing a document. That's not the way it works. They can't do that. So if an employer is calling you back to work and they want you to sign something, you have to get employment law advice right away. Get in touch with us right away so that we can provide you with advice on the document itself. But know that there's no obligation to sign anything. It may be that once you get employment law advice, you do sign the document, you decide to sign it because it doesn't have any effect on you, it doesn't impact you, it doesn't prejudice you. That might be the case, but it's important to know that before you sign, because once you sign, there's no going back, and then you're stuck with what you've signed. So that's why it's really important to get in touch with us. You can email us, you can call us. The number's on the screen, 1-855-821-5900. Any way you want to communicate with us, but get in touch, because once you sign, it's too late. So keep in mind, you don't have to sign anything, whether it be a document that says that you agree that a temporary layoff is now part of the terms and conditions of your employment after COVID. That's something that you should never sign, or whether it be a new employment contract, where we've seen this very recently a lot of the time, where an employer will say, given COVID-19, we've taken the opportunity to review our employment contracts and we're just updating them. So here's this new contract. It replaces your old contract. Just sign here. That's a red flag, because what that means is they're likely updating their contracts to try and limit some of your entitlements as an employee. And the most common one that we see is termination entitlements. The law on termination entitlements changes very often, and it's important as an employer to keep your contracts up to date, of course, if you're trying to limit your liability. But as an employee, the contract does not need to be up to date. The only reason the contract needs to be up to date is to effectively limit your termination entitlements, which would only be in favor of an employer. So that's why, as I always say to my clients, you don't need to have a written contract. There's no obligation to have one on either end, employer, employee, because for the most part, and if you're an employer, you know this, it's in favor of you as an employer. It helps limit liability. So as an employer, you want to have contracts in place. As an employee, you don't. And so if you're coming back from a COVID-19 layoff and you're being asked to sign a new employment contract, again, it's a red flag. Don't sign anything. Get in touch with us. Get proper legal advice before you agree to sign anything, if you're even going to sign, because it is not necessary for you to sign anything in order for you to be called back to work. What employers can do is, if an employee decides not to sign a letter or a contract or whatever it is that the employer wants the employee to sign, they can terminate employment because of it. So it's not illegal or unlawful for an employer to terminate employment because the employee wouldn't sign a new contract. That's lawful, that's okay. At that point, if that were to happen, the question becomes how much notice or severance pay is owed, and is that what's being offered? And in the vast majority of cases, the answer is no. In the vast majority of cases, I've had quite a few clients where they're confronted with a new employment contract and they don't want to sign, and the employer says, well, if you don't sign, we're going to let you go. They don't sign, the employer lets them go. And that's when we negotiate a proper severance package, because in the vast majority of cases, what the employer offers will not be enough. So that's one of the issues. We're just getting to the end of our time here, but that's specifically related to COVID-19 layoffs. A couple of the issues that have been coming up a lot more recently as people are returning to work, that everyone, both employees and employers, should be aware of to make sure that everyone is complying with the law, and that as an employee, you're able to enforce your rights and make sure that you're not doing something that you don't have to do, and that you get what you're owed if you are let go. So that just brings us to the end of our time today. Thank you very much for your questions. As I mentioned before, if you didn't get a chance to ask your question or you want to contact us directly, we've provided all the information to do that. You can go to employmentlawyer.ca and all of our contact information is there. And you can definitely get in touch that way so that we can assist you with whatever type of issue you're having. So thank you for joining us, and I will see everyone in the next question and answer session. Have a great week.